Under our Constitution, the President has the right and responsibility to nominate qualified judges. And the legislative branch has the responsibility to vote on them in a fair and timely manner. This process determines the quality of justice in America, and it demands that both the President and Senate act with care and integrity, with wisdom and deep respect for the Constitution.
George Bush says the President and the Senate must act with wisdom and deep respect for the Constitution to ensure the quality of justice in America. But has Mr. Bush shown such deep wisdom and respect? A number of Mr. Bush's judicial nominees have very extreme views and have provoked a partisan struggle in the United States Senate. Predictably, many Senate Republicans have been glowing in their support for these nominees.
This is an outstanding woman with an excellent, in fact, an outstanding record.
A person of such sterling quality.
You're a person of deep religious conviction.
He is superbly qualified.
He is truly a righteous, decent man.
This lady is a brilliant jurist.
Here's an incredibly well-qualified, broad-based individual.
She is the kind of person that we need on the federal bench with a lifetime appointment.
Because these are lifetime appointments, fair-minded senators, backed by advocates for civil rights, women's rights, consumers, workers, and the environment, have opposed these nominees and argued that Mr. Bush is trying to pack the federal courts with extremist judicial activists who would undermine the rights and protections of all Americans for decades to come.
Judge Pickering went the whole 9 yards and then some to get a lighter sentence for a convicted cross-burner. Why would anyone do that?
And you joined with Justice Hecht in a dissent in restricting the plaintiff's right to recover under age discrimination. It seems to me that you were moving in the opposite direction of civil rights.
That case directly affects thousands of children who suffer and die from asthma. You want to know why this nominee is important? He'll be making judgments in whether we're going to continue those kinds of protections.
These senators have a point. Over the past 50 years, our federal courts have handed down critical decisions that defined and protected our fundamental rights and liberties. Time and again, ordinary Americans turn to the courts to uphold these rights. But George Bush's extremist nominees are cut from a different cloth. They favor the powerful over the weak.
Individuals who have really been left out and left behind.
Large corporations over individuals.
I had some Texas lawyers come to me who are consumer lawyers, and they said their concern was they didn't believe they could ever get a fair shot in your courtroom.
Business over the environment.
Bill Pryor was the only state attorney general. Only one of 50 said that the Clean Water Act, large parts of it, are unconstitutional.
Would you call on the Supreme Court to abandon Roe versus Wade?
They believe the government has a right to interfere in our most private decisions.
Judge Pickering has also expressed troubling views in some voting right cases.
They want to turn back the clock on civil rights.
Some criticism of the concept of one person, one vote.
It's all there, on the record.
I have a record of standing up for equal protection, respecting the rule of law.
Charles Pickering's history reveals something quite different. As a law student, he wrote an article supporting legal restrictions on interracial marriage. As a Mississippi state legislator, he supported funding for the Mississippi Sovereignty Commission, an avowed segregationist organization. But his more recent actions as a sitting judge are the most troublesome. In 1994, Pickering was the federal district judge in a case where a man named Daniel Swan was convicted by a jury of burning a cross on the lawn of an interracial couple. When Congress passed this criminal statute, they specified a minimum sentence of 5 years. Even though Swan was convicted by a jury, Pickering tried to have his sentence reduced, seeking, in his words, to make the punishment commensurate with the drunken prank that I think it was.
Our challenge is not against him, the individual, it's against his record, which has demonstrated over the years an insensitivity and a lack of tolerance, particularly on civil rights issues.
Before and after this case, Judge Pickering had a reputation as a tough law and order judge. In fact, this cross-burning case is the only one in which he has ever forced prosecutors to drop charges on a criminal after he was convicted.
It's clear that the judge had taken sides in the case and had decided what he wanted to happen. And he was willing to either ignore or violate clear provisions in the law in order to get the result that he wanted to see obtained.
Mr. Pryor has described the Supreme Court's decision as in Roe v. Wade as Roe v. Wade is a creation, quote, out of thin air of a constitutional right to murder an unborn child. Mr. Pryor has said he opposes abortion even in the cases of rape or incest. He has described Roe as, quote, the worst abomination in the history of constitutional law. A, do you believe that as of right now?
I do.
Okay. This is what we have a hard time squaring, myself, I think some others. If you believe that Roe is the worst abomination in the history of constitutional law, it would seem to me to directly follow that you endorsed the courts reversing Roe v. Wade at the first opportunity.
Senator, I don't know what that opportunity would be, and that is a hard thing to speculate about unless I know more about what the case involves.
Your comments about Roe make one believe, could he really suddenly move away from those comments and be a judge?
Sanchez-Scott versus Alza Pharmaceuticals. In this case, a breast cancer patient went to her oncologist for a routine visit. During this visit, the doctor brought a man into the examination room. This man turned out to be a drug salesman for Alza Pharmaceutical, as the patient later found out. This man, this drug salesman, in the doctor's office watched the examination, which included removal of the patient's shirt and bra. Citing an invasion of privacy, the patient sued the salesman and the pharmaceutical company. You rejected the invasion of privacy claim by the breast cancer patient when this drug salesman was invited in the room to watch this woman disrobe for the medical evaluation. Would you like to explain your concept of privacy as it applies to that fact situation?
Yes, Senator. First of all, I think it's important to recognize in that case that her claim against the doctor that he didn't get her consent to allowing this third person to come in, that claim was going to go forward.
But I take it you rejected her claim against the salesman in the room and the pharmaceutical company that he worked for.
The Court of Appeal had, I think, a closer focus.
Right, but you were reversed unanimously by the Court of Appeals.
Well, I think that the appellate court in doing that clarified the law in what was a rather unclear area, and I welcome that. I certainly would follow that law in the future.
You said, as I understand it, that because she didn't ask questions and object, Ms. Sanchez lost any right to privacy she may have had. You also agreed with the defendants that no reasonable person would have found Mr. Martinez's presence to be highly offensive, and that this was nothing more than, and this is your words, a situation which she found socially uncomfortable. Socially uncomfortable.
There is remarkable unanimity on these critical issues among Mr. Bush's judicial nominees. Carolyn Kuhl's civil rights record is similar to Charles Pickering's. When at the Justice Department, Kuhl argued for reinstating the tax-exempt status of Bob Jones University, a school that prohibited interracial dating. William Pryor, as Alabama Attorney General, has called for the repeal of part of the Voting Rights Act, which was passed to protect the voting rights of African Americans. And Pickering and Kuhl agree with Pryor on abortion. Indeed, many of Mr. Bush's judicial nominees have similar records, hostile to civil rights, reproductive rights, and the interests of workers, consumers, and the environment.
It's time to get the Senate in the hands of people who will approve the good jurists I send, so we can have a federal bench that will not from which it will not legislate from, but will strictly interpret the Constitution of the United States of America.
Mr. Bush is, of course, free to nominate anyone he chooses to the federal bench. But when those nominees are so extreme that they threaten the rights and liberties all of us hold dear, it's not just the Senate's constitutional right, but its responsibility to reject those nominations.
Look back in history. The political branches share the power of appointment. The president has the power to nominate or propose judges, but the Senate has a corresponding power to confirm or reject those nominations. It is not a rubber stamp. Even George Washington had the Senate reject some of his judges. It's an ingenious check and balance of our federal system.
We on our side of the aisle have talked about, as I said, how many of these White House judicial nominees are out of the mainstream in general. But when you go over the record, one after the other, it becomes even clearer. And the clearer it gets, I think the more worried mainstream Americans will get. I believe that 10 or 15 years from now, there's going to be a rebellion if the president gets his way and puts every one of his nominees on the court, because they're going to be doing things that most people find outrageous.
Mr. Bush has nominated these people to the federal courts of appeal, which are the courts of last resort in virtually all cases. And should a Supreme Court justice retire, he is likely to name an equally extreme candidate to our nation's highest court. If the records of Mr. Bush's judicial nominees concern you, speak up. You can make a difference. People like you already have. And for more information on how to get involved, go to this website.